So, hello everyone. Welcome. Hi Paul. My name is Beth Fisher, and I am the adult program librarian at the public library in Iowa City. And this is our Writing a Will Introduction to Estate Planning program. This program came out of a discussion with some coworkers about what our New Year's resolutions were. And there were only like 6 of us in the discussion, and 2 of us said our New Year's resolution was learning how to write a will. So I asked around to other libraries to see if anybody had done a program. And West Branch had nothing but wonderful things to say for Kandie, because she's done 2 programs from them on this, and she was more than interested in doing the program for us tonight. I am here. There is another person here whose name says Iowa City Public Library. Her name is Bon Dreger, and she is our IT person. There she is. And so we are here to keep things running. All right, our guest tonight is Kandie Gelner, and I'm going to let her introduce herself because the names that go with her law firm, I can't keep straight and who's who and everything. So take it away, Kandie.
Thank you, Beth. I appreciate it. I was excited to do this because I enjoy giving the presentation, and I would much prefer to be in person with all of you, but this is as good as it's getting right now. So this is the second time I've done this on Zoom, and we'll make it work. So actually, coincidentally, today is the 25th anniversary of my being admitted to the bar. So I've been an attorney exactly 25 years today. Yes, pretty exciting. Yeah, it's also a really long time, and it's kind of intimidating, but oh well, is what it is. So I've been with the same firm, but law firms change their names and the lawyers kind of come and go. So currently the name of the firm is Kandie, Gelner, Cronk, and Waterman, but our office has been in the same location on South Dubuque Street, across from the Johnson County Administration building since the mid 80s. So we've been here a long time. It's a firm that's well known in Iowa City. I'm originally from Mason City, but like lots of people, moved down here to go to the University of Iowa and never left. And I tell everyone, if you're going to live in Iowa, Iowa City's the place to be. Okay, now my practice is primarily, I'm going to try to do this screen share thing. There we go. Okay, so contact information, and I am happy to, talk to people, answer questions, or refer you to another lawyer that can help you better. But there's my contact information. What I do mainly is estate planning is a very big part of my practice, elder law. Estate planning is before, that's planning ahead of time, but I also do probate, which is after somebody dies or becomes disabled. I also do a lot of real estate. I do corporate work. I set up businesses. I guess I say I have the kind of practice where I just try to help people. All right, so let's get into. All right, so we are doing kind of estate planning 101. So the objective here is to really give you an overview. So when you go and talk to your attorney and you want to do estate planning, or you're considering what you should be doing or maybe want to do, that you kind of know the vocabulary and have an idea of how all of the pieces of the puzzle fit together, because I really do consider this like a package that you have to consider and make it all fit together. Okay, so some of the things we're going to cover here, I've got listed on this first slide, is I want to talk about what is testate versus intestate succession. So that is with a will or without a will, and how does that affect things? And then we will talk about the different things you can use for meeting your objectives. Obviously, a will That's kind of what everybody thinks of. But trusts are an important tool that we use in estate planning, and there are many different types of trusts and reasons to have trusts. So we'll go through those. A very important tool you have is beneficiary designations. So those are very powerful, and they are part of the package or the puzzle, your estate planning overall. How you title your accounts or assets is a very important part of estate planning too. So you might not have considered all of these different things, but we're going to talk about how they all fit together in your estate plan. The other part of estate planning is we typically include in that label estate planning, disability planning, as well as death. So we'll towards the end of the presentation, I will spend a few minutes talking about power of attorney forms, a power of attorney form for financial purposes, a power of attorney form for healthcare purposes, and then also a living will. So those are all things I really think people ought to have. And then after we talked about all these different pieces, we will also talk about what's an appropriate use of them, how do they get you to satisfy, your objectives. Okay. So a big part of estate planning is just sitting down and figuring out what is in your estate. And if you go talk to an attorney, or even if you're talking to your investment advisor and you're saying, do I need an estate plan? One of the first things you need to do is figure out what is in your estate. Sit down, and this is a good exercise for people to do. I actually had an experience one time where I had an elderly client, and she wanted to help her granddaughter pay for college, but she didn't really want to sell any of her stock. So she decided she wanted to borrow money. And she had plenty of assets, but she didn't want to liquidate anything. So she went to the bank, and the bank said, well, you need to do a financial statement. You need to do this, like figure out what you have. And when we did, we realized her estate was like over for $4 million, and she had no idea. Once we knew that, that triggered her doing some, different kind of things with her estate plan. And so kind of having an idea of what you've got, and hopefully you have a better general sense of your estate than she did. She had no idea she had that much money. So take the time to list out everything. And it does, sometimes there are things you'll forget about, like the savings bonds you got in your safe deposit box, or life insurance is something people often leave out because that's not really an asset until you die, but that does come in as part of your estate. And it matters for your beneficiaries, obviously, but it also is part of the plan. Do you have enough liquid assets? It's a whole package that we're trying to put together to make sure that you have enough money for the people, for the taxes, for, paying expenses, all the things that you want to happen. So real estate obviously matters. And we need to know where the real estate is. Is it in Iowa? Is it somewhere else? Is the real estate owned by some kind of a business entity, like in a partnership or a limited liability company? All of those things matter. Listing out your bank accounts, and CDs and all of that kind of stuff, and whose names on each of those accounts. Obviously, we want to know about stocks, bonds, mutual funds, investment accounts, but also, like I said, savings bonds. I mentioned life insurance. Annuities are something that sometimes people kind of forget about because they will put money in there and it sits for a long time and they're not receiving income on it, but that's an important asset, and those have beneficiaries often. So we want to figure out how those fit into your plan. Retirement accounts are very big assets for lots of people. And it's very important to think about how much money you got in those, who your beneficiaries should be, because that is a particular asset that has got tax issues related to it, because that's typically pre-tax money people put in there, and it can be very large. We've got a lot of people who work at the University of Iowa here in Iowa City, and so there are some really big TIAA CREF accounts, and those need to have some special planning and consideration. So listing that out in your estate is important. Family businesses are a tricky one. That's something where it's often hard to put a value on them, but it is very important to think about what's going to happen to the business when you're gone. So that's very important to do some planning. And then think about your stuff, your personal property, the stuff you have in the house, the things that have sentimental value. I will tell you that I've done a lot of probating estates in the last 25 years, and nobody fights over splitting up the investment accounts. They fight over your stuff. They fight over your wedding ring. They fight over grandpa's rifle. I've had a fight over a red couch. So that's another thing that we have to think about, include here, and make a plan for. Okay. Okay, so I've kind of been interspersing as I'm going through here, what some of the reasons why you should be doing this. But let's talk about, why should you have an estate plan? An estate plan is going to help you be in control. And I don't mean control in a bad way, but I mean provide direction for your beneficiaries and the people who are going to take care of things when you're gone. So the more that you can provide guidance to everyone, I think often is going to help us avoid problems. So if you tell us who should be in charge of your trust, or who should be the executor, or who should have power of attorney, that stops everyone from fighting, or at least it's less likely to fight, because we know who you want. And so that's super helpful. You also obviously you control who inherits. If you don't tell us, then Iowa law is going to control who inherits, and that may not be what you want to happen to your property. Another controlling or providing direction is, if you want to keep some restrictions on property, or have beneficiaries who need assistance in managing the property once they inherit it, like you have children or grandchildren who are too young to manage property, or you have beneficiaries who might not have, or that you might not feel comfortable just handing the money over, and they need some help investing and doling the money out for them for whatever reason, or it's family property like farmland or a business, and you want only the income to go maybe to a spouse or to the kids, but you ultimately want to control where that goes, to keep it in the family, or to make sure it gets to grandkids or whatever. So there's lots of reasons that this kind of control or providing guidance to us can be extremely effective in, getting stuff where you want it and making it cost effective and without disputes. So, that's what my next line is: minimizing problems and disputes. So I think often that is huge, and you're going to name somebody that you trust to, direct things. You're going to name somebody who's going to communicate effectively. And if you can give us in your documents that kind of insight into your family, that typically helps us afterwards navigate through the whole probate procedure. If you minimize problems and disputes, we're hopefully also saving money on taxes and other expenses. So there are lots of ways to save money, to consider what's going to happen with your estate and save money. For example, Iowa still has inheritance tax. In Iowa, you can leave property to your spouse or to your lineal descendants, meaning kids and grandkids, free of any inheritance tax. But if you don't leave it to spouse or lineal up, right, straight up and down, your parents or your children, grandchildren, up and down the family tree. If you leave it to anyone else, it is subject to Iowa inheritance tax. So if you leave it to your siblings, they're going to have to pay Iowa inheritance tax. If you leave it to nieces and nephews, Iowa inheritance tax. If you leave something to a friend, it's subject to Iowa inheritance tax. Now, there are ways to get around that, that we might do. There's lots of strategies to avoid inheritance tax if you know ahead of time. But if I don't know ahead of time, or your attorney doesn't know, there's no way to educate you and give you some options on how to move things around. Another big one is liquidity. And you might not think that's such a big deal, but I have run into several estates where the bank accounts were set up with joint owners. And so they just went to those people, and all the stuff, the life insurance goes to somebody and the retirement account goes to somebody. And all I've got in the estate that's passing under the will is a house, but no money. I got a problem because I don't have any money to pay for the utilities and all the, keeping the house up while the administration of the estate. So that can be a real big problem, especially, one of them I had, the house was actually supposed to go to somebody too. We weren't supposed to sell it. And so the beneficiary actually had to borrow money to put it back into the estate so that we could process things. So liquidity is an issue. And if you are going to have taxes and you know about it, we can take that into account and make sure that there's money available to pay taxes and expenses and all that kind of thing. Okay, so now here's a list of some of the really important tools that we use for estate planning. So some of these pieces of the package that we're putting together. And we're going to talk about each of these as we go. Oops, just hit the wrong button over here. So joint tenancy. I think lots of people have accounts owned jointly, or you have your house, your real estate is often owned jointly with your spouse. And most of the time it is joint tenants with rights of survivorship. That's just how we set it up. That is important because these are all ways that we control where property goes. So beneficiary designations, something everybody knows about. You put beneficiary designations on life insurance, you put them on your IRA or your 401k plan. Will, we are of course going to talk about a will and how that works. And we're also going to talk about trusts, many different forms of trusts and how those can be useful. And then lastly, as I mentioned earlier, we're going to talk about power of attorney forms, which are used for disability. Those are while you're alive, but those are also part of estate planning tools. Okay, so let's go into some of these in detail. Joint tenants with rights of survivorship. As I mentioned, real estate is a very common one. It is often spouses in particular, but I will tell you that this is something that is very important. If you assume that you and your spouse, because both your names are on, everybody says, oh, it's in both our names. It's in both our names. Because I say, do you guys own that as joint tenants? It's in both our names. That is not joint tenancy with rights of survivorship necessarily. It actually, anytime prior to about, the law just changed about 3 years ago. Prior to that, it had to specifically say Mr. and Mrs. or whatever, spouses as joint tenants with full rights of survivorship. If it didn't say that, it didn't control who inherits. So joint tenants, typically this rights of survivorship means survivor owns the whole thing. So whoever dies first, it just passes to the survivor. Now, sometimes there could be 3 or 4 people on. So if one person dies, the 3 left own the whole thing until you get down to last man standing. Whoever's the last survivor is the one who owns 100% of the thing. So joint tenants with rights of survivorship means the property automatically transfers title when one of the other owners dies. That applies on bank accounts, investment accounts. There's a lot of different accounts that you can set up with joint tenants. Then a lot of times it just says joint tenants. It doesn't have the rights to survivorship except for on real estate transfers. The alternative to that is you can be on the title, and if it doesn't say, or it might say tenants in common. What that means is if it's two people and you own as tenants in common, each of you owns half of the property. It's called an undivided 1/2 interest. So if the first person dies, their half goes to their heirs, whoever they put in their will, not necessarily to the other owner. It goes off to whoever. So if this was unmarried people, it could go to this person's spouse or what. So maybe these are siblings. This goes to this person dies, it goes to their spouse or their children. And now this guy owns a property with somebody, his nieces and nephews, or who knows what. So it's an undivided interest that goes separate ways. It doesn't pass to the survivor. Okay. Another way to control where property goes is by using beneficiary designations. So the interesting thing about these tools is these trump a will. Okay, so if we look at you own an account jointly with someone, it doesn't matter what your will says. It doesn't. Your will could say, "I leave all my property to my children." But you have, if you say you've got 5 kids and you want all your property to go to your 5 kids, but at some point you think, oh, it'd be really good if I had my daughter on there so that she can help me write checks. And so you go to the bank and you add your daughter on as onto your bank account. Well, the bank will often, and I've had this happen many times, add the daughter as a co-owner on the account. That would make you joint owners. And what happens when you die then is your daughter inherits the entire account to the exclusion of the other 4 kids, because it doesn't matter what the will says. It's controlled by the ownership of the account. It's real estate is controlled by the title on the real estate, and a bank account could be controlled by title on the account. If there's a joint owner, it goes to the joint owner. In fact, I have an estate right now I'm just opened up, and I have 2 bank accounts just like that. One has 1 kid on it and one has another kid on it, but there's 4 kids. And so now 2 of my bank accounts went off to 2 of the kids because mom was doing some, whatever with whatever. So that can be a big problem. Beneficiary designations similarly will control before you look at a will. So if your life insurance says, I leave this life insurance to whoever, I want money to go to my sister. So I leave that to my sister, or I had my sister on there before I got married and had kids. That if I forget to change that, and now I've got a will and I want everything to go to my new spouse and my kids, it still goes to my sister. They don't look at the will, they look at the beneficiary designation form. Now, the thing you should remember is that, or that you may not know, is that beneficiary designations can be used on a lot more than you would think. So everybody knows life insurance, right? Retirement accounts are one. They ask you, who do you want to list as a beneficiary? So most of the time we see there's beneficiary designations on retirement accounts, IRAs, 401ks, 403b, all of that kind of stuff. But you can also have a beneficiary on an actual bank account. If you have a beneficiary on a bank account, you actually, it is called a pay on death designation, a POD, pay on death. And you can do the same thing on an investment account. So you got an account at Edward Jones or Raymond James or Morgan Stanley, whatever. You can say, I'd like to add a beneficiary designation to my account. And that is called a TOD, a transfer on death. Now, the beauty of these is that maybe you don't even need a will. Maybe you can just do these beneficiary designations and all the stuff you have, and you control where it goes. And then you don't need a will, and you don't need, any executor or any of that stuff, because the life insurance just goes under a beneficiary designation or a transfer on death designation. So that might work, but you have to be very careful about it, because you might also, if like I see, had something going to my sister's actually going to owe inheritance tax on that, and now I don't have an estate or an executor to file the tax return and pay the taxes, and I kind of might have created a bit of a pickle for my sister, which I've had one of those too. So that sometimes using all of these beneficiary designations and avoiding probate is not always the greatest thing to do. But it can be a really powerful tool to use, as long as you consider the whole package and what your objectives are. Okay, so the last thing is here is align with your overall estate plan, which is super important, and then review it regularly. I mean, at least every 5 years, go and look, excuse me, go and look at who your beneficiaries are. Because I see many, many problems because people forget to update the beneficiaries. Excuse me. I sometimes have dead parents are still beneficiaries of life insurance. I have dead spouses are often still beneficiaries of policies or accounts. And this can cause a lot of unintended problems. It can cause tax problems, and property is going to go where they didn't intend it to go necessarily. So it really is important to review those beneficiary designations, because those are something people forget about. And they are out there and they're 20, 30 years and they don't change them. Okay. Okay, this is what you've all been waiting for, a will. So a will, I am a lawyer and I do make money drafting wills, but I am going to tell you, not everybody needs a will. In fact, there are a lot of people who don't need wills. So here's how you know if you need a will or not. If you die without a will, your estate is intestate. Intestate. If you have a will, it is testate. So doing a will is, a formal procedure of drafting it up and telling us exactly what you want to do. And there are a lot of benefits of that. But if the intestate distribution, so if you have no will, I have lots of people who say to me, oh, so my stuff is just going to go to the state. I hear that a lot. That is not the case. That is not the case. What intestate means is that the state of Iowa is going to control where your assets go. So if you have no will, we first ask, do you have a spouse? If you have a spouse and it's your only spouse and you have children together, everything goes to your spouse. If you have a spouse and you have kids from a prior marriage, some goes to spouse, some goes to kids. No spouse, all to the kids. No spouse, no kids, then we go to parents up the tree. If parents have predeceased too, we go to siblings and so forth and so forth. So it goes all out to your family tree. And I am currently probating an estate of a fellow who actually had a law license and died without a will, at least one that we could find. And he was never married, no children. His brother predeceased him. His parents are gone, and his grandparents are dead as well. We have, actually not me, but his family tree has been researched, and his money, which in his estate is more than $2 million, it's actually close to $3 million, is going to 52 cousins in varying shares. Some of the people on that millions of dollars are only getting like $10,000. Others are getting a pretty big share. So it just depends on how closely you're related and how the tree breaks down. But it's actually was kind of a fun exercise trying to map that whole genealogy out and figuring out who inherits what. But it doesn't go to the state unless we cannot find anybody related to you that would inherit. So it'd have to be, I mean, he'd have to have had no family at all, even out second cousins twice removed kind of thing. Um, if you if your property, you just want all your property to go to, your spouse or to your kids, and you don't have any restrictions, you don't have anybody who needs help dealing with their property, you don't have any special considerations, maybe you don't need a will. And or maybe you have assets that you can set up so that you don't have any real estate, and you can set up things so that they all go through beneficiary designations. You might be able to avoid having a will, but it still might be worth talking to an attorney to get some advice to make sure that you could have considered tax issues, and some of these other things that we've talked about. So a will is, I know people do, can do wills themselves sometimes. I don't recommend that because in Iowa we have some pretty strict execution formalities that have to be followed. So a will in Iowa must be executed in the presence of two witnesses. And that's really important. In fact, there's a case where they said, I think somebody was executing their will, on their deathbed, or they were very ill and they're in the bedroom and all the witnesses come in there, and the guys or whoever, I don't know, it was a man, I think it was a man, says, yeah, I want you to witness my will. And so the witnesses turn around and they sign the will on the dresser, but they have their back to the person whose will it was, the testator, we call it. That's not a valid will. The testator, the person who's writing the will, and the witnesses must see each other sign the will. I mean, that's kind of a silly little thing, but it's important and it could invalidate your will. So it's important. We also, most attorneys include an affidavit on the end of your will, because if you don't do that too, then they have to come after you die. We have to go find the witnesses who have to swear that they all saw each other sign the will. It's called a affidavit and testimony of subscribing witnesses. So we don't really want to have to do that either. And so there are some formalities. So if you're going to do it, I tell people it's kind of like insurance. Do it right, pay to have a good will drawn up, get some good advice, because I think in the long run, it's worth it. Okay, so what can you do in a will? One of the things obviously you do is choose an executor. The executor is the person who gathers up your stuff when you die and gives it to the people that you're supposed to get it. They file the tax returns and, sell the house or whatever it is that needs to be done. The will also is going to, obviously, the big thing, say who inherits. That's really important. The will can also control, all kinds of things. It can be jewelry, it can be other stuff, but there is a provision that if your will mentions a memorandum that you left, you could actually write up just a handwritten list that says, I want grandma's wedding ring to go to my cousin, and I want whatever special items of personal property. You can make a list of who's supposed to get those. And even if it's not in your will, we just have to mention it in your will. That is binding on the executor, and it can be a pretty powerful little tool that people can use to identify specific things. I had a client one time who used little tags on items she was an artist. And so she had artwork up on her walls. And I said, well, we have to be able to know which picture you're talking about. So she put numbers and people's names on the back of them and had her list. So we knew who got what. Or you could take pictures. If it's jewelry, we don't say the ring or the diamond ring. If you got 3 of them, you got to figure out what it is, take a picture of it, or somehow make sure you identify it. But that is a kind of a powerful tool, like I said, that you can use, and you can do that over and over again without paying an attorney, without updating your will, you can just handwrite this list as long as it's signed and dated. And then we have to be able to find it, of course, when you die. That is just as enforceable as if it was actually in your will. So that's cool. Charitable giving is really important. So if you don't have a will, I told you the state hierarchy for intestate, that doesn't include giving any money to charity. So if you have some charitable intention, you want to give money to Iowa City Public Library, or you want your church or whatever, you need to say so. So you've got to include that somewhere, either in a beneficiary designation or in your will, so that charitable intention is realized. If you have children, I think if you have young children, you need a will. And there's not really any exception to that. It's for two reasons. One, you need to name a guardian. Now, you don't actually appoint a guardian, you nominate one, and then the court approves it later after you're dead, because you don't need it until you're dead, obviously. But it really helps if the court will typically appoint who you name. And it helps a lot to prevent disputes and fighting if you tell us where you want your kids to live, who should be taking care of them. This also would be inside of a will. You can have testamentary trust, and we call it a testamentary trust. Here, this is one of your vocabulary words. You're going to sound smart now, because this is a trust that is inside of your last will and testament. So it's a testamentary trust. Okay, so that's what any kind of trust that's inside of a will. And a lot of times these are kind of conditional or contingent trusts. They may not always even come into effect. So you say, I leave all of my property to my spouse, but if my spouse is gone, then I leave it to all my kids, or maybe it's all the way down to grandkids. But some of my kids or grandkids are too young. And if any money is going to go to somebody who's under the age of 25 or 30 or whatever, I want to trust, which means you just get to keep control over it for a little while until some conditions are met. It can be for their whole lifetime, or it can be till they're old enough, or there's lots of ways we can set it up. But that's a testamentary trust. Now, the drawback of a will is a will must be probated, which means it has to be submitted to the court. So I have people say all the time, oh, my mom, I'm the executor. My mom died, I'm the executor. Well, actually, it's like the guardian, what I was talking about. You are nominated. They said, I would like somebody, my daughter, to be the executor, but you are technically not the executor until the will is filed with the court and the judge approves that and appoints the executor. So it is a court appointed position, actually. And once you file the will with the court and you have an executor appointed, we have probate through the court. The drawback there is, one, it's public. It triggers court costs. We're going to talk about, comparing using a will versus using a inter vivos or revocable trust. But it does require filing with the court and appointment of an executor to pass your assets. Okay, next, a revocable living trust. So this isn't for everyone, but a revocable living trust is something that is just another option. It is sometimes referred to as a will substitute because it can do all the same things that a will does. It names your beneficiaries. It names who's in control when you die. It names, the trust can continue on. So it can go on after you die, just like testamentary trust. We can have the revocable trust become irrevocable and go on. But while you're alive, and this is a revocable living trust, is one that you set up while you're alive. Sometimes it's called an inter vivos, meaning while alive trust. And it is the main purpose of it is to avoid filing stuff with the court. And I'm going to show kind of a comparison here in a second so that we can talk about them. But it does everything that the will does And it does a little bit more because it's in place before you die. It actually organizes all of your assets, and it is in effect if you become disabled. So it names a successor trustee, somebody who's in charge and can control your assets if you become disabled or otherwise can't manage your assets. Okay, so here's our comparison. So a will versus, and this trust is only, I'm talking about a revocable trust or an inter vivos trust, the kind of trust you set up and get in place before you die. And it is completely revocable, changeable, amendable. You can get rid of it, put stuff in, take stuff out. Like a will, you can change it whenever you want to, okay? So the biggie, the real reason, the main reason that people do a revocable trust is to save money. If you have a will that has to be filed with court, you immediately trigger court costs. So if your estate, all the property that you own, when you die, say you have $1 million. When you die, the court costs, as soon as we open that estate, the court is going to charge a fee of roughly $2,000, 0.2%. And attorney fees are typically 2% of the gross value of the estate, so $20,000. Now, that is, I will tell you, is kind of a standard in Iowa. There is a statute that says attorney fees that may be charged are a maximum of 2% of the gross value of the estate, maximum, okay? But it has become a standard in Iowa that most attorneys just do a flat 2%. It's just a thing. I actually am opposed to that, and I've been trying to change that practice. And if only by example, my office does not charge that. But even if I don't handle an estate, I often empower people to go back to their attorney who is going to handle, or they want to, dad's attorney is familiar with all the stuff and we'd like him to do it, but do we really have to pay him 2%? And I was like, well, tell him you bring it here and then maybe he'll negotiate with you, because I don't charge 2%. So I'm empowering you. You are going to save like oodles of money just by, this is the one tidbit. If you have to ever be an executor, or your siblings or executors or whatever, tell them that 2% is not set in stone. That is something you can negotiate. Okay. A lot of attorneys will just say 2% is what we charge. And they don't tell you that that's something that can be negotiated. Okay. Executor fees has kind of the same thing, is that there is a maximum of 2%. A lot of times people don't charge if it's an individual. So it's one of the kids who's inheriting the money, or it's the spouse who's acting as executor. They often don't even charge that executor fee. But if you have, say you have a bank who's acting as executor, they are going to ask for the 2% fee. Or if you have somebody who's unrelated, and sometimes that happens, or if you got somebody who's doing it because there's little kids, and they're not, the person who is acting as executor is not inheriting, they will often collect a fee. So I'd say, about 20% of the time we have an executor who will also charge up to a 2% fee. For a trust, it's different, because on the court costs, there are no court costs, because the whole point of a revocable trust is staying out of the courthouse. So what we're trying to do is make everything private and control things without having the court appoint any kind of fiduciary, a person to help us. So we can do everything privately. And when the trust owns the property and the trust says where it goes, I liken this into the revocable trust is like setting up a company. So if you have a company and you've got somebody, John is the president of this corporation, and then John dies, well, the corporation still keeps going on, and it's just the vice president becomes president, and it's no big deal, right? Well, the trust is kind of like that. We set up the trust owns property, the trust has a trustee, like the president of a company. And inside of this trust, we've said, if something happens to the trustee, we want this next person to just step up and take over. And so the trust just keeps going on and does its thing, even when the person who set it up dies. And that means we don't have to go to the courthouse. We don't have to have an executor appointed. We don't need any judges. We don't have court costs. So we've instantly saved $2,000. We typically are saving some money on attorney fees. Even if you have an attorney that says, 2% to probate, they will often have a much lower fee to administer a trust after you die, because a lot of the setup has been done when you set up the trust. It's more complicated and more expensive to set up, but it's cheaper at the afterwards when you die. Now, here's another comparison is privacy. When you probate a will, we're required to file an inventory of all of your assets, and that is filed up at the courthouse and everybody can see it. When you do a revocable trust, we're staying out of the courthouse. So if the inventory that we compile is completely private, nobody ever sees it, other than the beneficiaries, obviously, and the trustee. So I have had times where I've got, young people or single women who are inheriting a lot of money, a good chunk of money, and they don't really want everybody to know that they just inherited $2 million or whatever. A couple of times I have actually asked the court to seal the record so that it wasn't public. But another way to just keep it completely private is to have a revocable trust. Probating a will and probating a trust, there is a little bit difference in how fast or how slow it takes or how long it takes. Probating a will is a little bit slower because we've got to wait on judges, and it's not a huge difference in the time frame, but it is definitely faster to probate a revocable trust. A will has nothing to do with incapacity or if you are not capable of managing your finances, a will won't help you, because a will only comes into effect after you die. Okay. So you have to, we can talk about power of attorney forms for that gap, but a will has no effect until you die. A revocable trust is in place now while you're alive, so it does control any assets that are inside the trust are controlled by the trustee. And if you can't be the trustee, you've named somebody to step up and take over. So it does have a plan for that. As far as cutting off claims of creditors and making sure your bills are paid, a will and a trust work the same. And the one downside of a revocable trust, as I mentioned, is relatively complicated to set up. It requires a lot more work and fees. So an attorney definitely has to help you with this. It requires retitling some of your assets or changing beneficiary designations. So it's pretty complicated and somewhat more expensive, but you save money and time and get privacy out of it in the long run. So I tell people when we set this up is that it doesn't do you really any good at all. It helps your beneficiaries. So it doesn't save my clients any money at all. It saves money for their kids or whoever's inheriting from them. It makes it easier, faster, and cheaper for the people who are inheriting. So there you go. So if you don't care about that, then don't waste your time on all the complicated and expensive doing a revocable trust. It also is typically, I don't really think about doing a revocable trust unless your assets are your estate is relatively large. And by that, I mean at least $1 million or more, because a lot of these costs that we're talking about are percentages. So the bigger your estate is, the bigger those expenses are. And so the bigger the savings is by doing a revocable trust. Another reason to do a revocable trust would be if you have real estate in more than one state, you're making the court costs could be getting bigger and bigger, because say you've got a house in Arizona and you've got a house in Iowa, or you got farmland or whatever, you have to probate in both states. And then now we've got court costs down in Arizona, we got court and lawyers, and we got up in Iowa. If you use a revocable trust to own at least some of that property, you might be able to reduce your expenses. So that's another reason to think about a revocable trust. Okay, let's go to, whoops, I clicked the wrong button. There we go. Oh, okay. So, oh, this is good. All right. Because it's almost 8 o'clock. All right. So those are all lots of different ways to make pieces of your estate plan fit together, and everybody's situation is so different. So that's why it really requires, listing out all of your assets, thinking about who you want to have them, restrictions that you might want, and then trying to fit all of the pieces together as far as beneficiary designations and ownership and a will or a trust. Now, we also, and if you get nothing else out of this presentation, everybody, I don't care how old or young you are, should have power of attorney forms. And this has really become important in the era of COVID. I really think and it was always, I've always recommended that everybody do these. I think sometimes people don't think they need a power of attorney form until they're, older or have health problems or something. That's often too late. If it happens that you get sick and you cannot make your own financial decisions, you can't pay your bills, you can't sign your tax returns or whatever, you need to have someone designated who can handle stuff for you. I had, here's an example. I had a couple, because the other thing is the bottom one: failure to execute a general power of attorney, a durable power of attorney, may require conservatorship. A conservatorship is very expensive to set up, relatively expensive. And I mean, thousands of dollars. And it is all, again, it is court supervised. So it's all public, and it's got you got to file reports and the judges to approve everything. And it's can be really onerous and expensive and time consuming. I had a couple who was married for, I don't know, 40 years, and the husband handled everything. And his main asset was a very large TIAA CRUF account. A couple $1 million, I think, that was one of their biggest assets. And they had no power of attorney forms. And just very suddenly, he had a series of strokes, but right about Christmas time, and could not do anything. And so his wife came into me and she's like, I need to find out, can I pull more money out of his TI craft? I need to sign the tax returns. And I said, well, do you have power of attorney? No. The only way for her to manage his financial matters was for us to get a doctor's statement saying he was not capable of managing finances, file that with the court. We have to hire an attorney for him. She has to have an attorney. We got to pay court costs. It probably costs, I don't know, between $3,000 and $5,000 just to set it up. We have to report every single payment, every dollar coming in, every dollar going out of his money every year on these very detailed reports. They had to split their bank accounts because otherwise we were going to have to report how much she spent on groceries and every other thing. And this all could have been avoided by having a power of attorney form. It's a very simple document. It is relatively inexpensive. I do a package of power of attorney forms, and it's maybe $200 or $200 to $300 just to do those. It is so worth it because it could save thousands of dollars. You can make these pretty specific, so you can say when the power of attorney goes into effect. Sometimes we have them in effect, while I'm traveling the world for the 2 years, or while whatever. You can have them a time period. You can say you have to prove I'm incompetent before it goes into effect. There's lots of ways to tailor these to make you comfortable and fit your situation. But this is an inexpensive document and everybody should have one. In fact, I made all of my kids who are in their 20s do them this summer. Every one of them has a POA. Okay. So we were talking about a power of attorney, a durable power of attorney, or a general power of attorney. That was for financial purposes. The other power of attorney form that everybody should have is a medical power of attorney form. So this is for healthcare decisions. This designates who should make healthcare decisions for you if you are unable to do so. So, and it says right on it, if I'm unable to make healthcare decisions for myself, in the opinion of my treating physician, then I name somebody to do it for me. Even if you're married, this is important, because I know everybody's like, ah, it's just my spouse. Well, it would make, do you want your spouse? I mean, if you just want your spouse, then it's probably okay. But maybe you want to name a backup. What if you and your spouse are both in the same car accident? Then what? Then who's making the decisions? For my kids, my husband and I are both in a second marriage. So I wanted them to say, do they want their dad? Do they want their mom? Do they want one of their siblings? Because he's got two kids. I got two kids. We got ex-spouses, it's complicated. So I really wanted them to think about who should make decisions for them, and say so. And I don't want to be fighting with my ex-spouse about who's making the decisions. So, I mean, there are a lot of complicated families, and I think it's a really good idea to think about this. We also had this come up, and this is obviously a big deal with COVID. If you're put on, you're ill and you're in the hospital and you can't take care of stuff, who should be making decisions for you? And we had a situation. It was a relatively young woman, and she went in for a surgical procedure, and she had a reaction to the anesthesia, a terrible reaction, and she was put on into a medically induced coma. And the husband was a Jehovah's Witness, and her father was not, and she was not a Jehovah's Witness. And and then the issue came up: should she have a blood transfusion? And I don't know what she would have wanted, because she didn't have a medical power of attorney form. And the husband said she wouldn't want that, because I think she agrees with me, Jehovah's Witnesses, and that she wouldn't want a blood transfusion. And her dad said, I think she wants to live. And if that's what we need to do, that's what we should do. And I should be in charge. And we had a pretty a very unpleasant situation was created when the family should have been united and trying to work together and communicating, and it was really ugly. And it damaged that family. I hope not irreparably, but it really damaged family relationships, because there was a lot of fighting, and she ended up not needing the transfusion, but we had a court battle going on, and it was ugly. So say what you want. Again, this is a part of providing direction so that we can avoid disputes. The clearer you are, the more direction you provide to people, the better off everybody is, in my opinion. And if you don't have the medical power of attorney, and we don't know who's supposed to be making decisions, we have to go and have a guardianship. It's sort of like I was talking about the conservatorship. That is a court ordered, it's a court proceeding. The judge appoints the guardian. They have to file all kinds of reports with the court. So it is public, it's time consuming, it's expensive. And by having a relatively simple piece of paper, you can avoid that. In fact, for the medical power of attorney, you don't even need an attorney to help you with that. There is a program called Honoring Your Wishes. And in Iowa, they're trying to get everybody to have a healthcare power of attorney. And so if you Google Honoring Your Wishes, you can find a form that actually does this. Fill it out yourself. You have to have a couple witnesses or a notary. And it actually has some extra stuff besides the bare bones. Like you can be more specific about some of the healthcare decisions you want made, but you can do that one actually all by yourself. And I strongly recommend that everybody have these. The last one, the Honoring Your Wishes program, and typically I offer as combining with a medical power of attorney, is a living will. And that document says, in the event it is unlikely I'm going to recover, or basically if there is no brain function, or they don't think you're going to live, that should they remove life support. And if that is something that if it's appropriate, obviously, it's not like we just pull the plug willy-nilly, but if the doctors say, yeah, there's no hope here, do you want to remove life support? If you do, you should have a living will. Tell the people who are making the decisions, give them the very specific authority to do that. If that's not living to you, being kept alive on a respirator or whatever, then say so. There are also a few other things that are kind of extra is advanced medical directives. People have heard of those. Those are much more detailed. They're kind of like a living will and a medical power of attorney, but they provide a lot of detailed instructions to the people who would be making medical decisions for you. Do you want antibiotics? Do you want fluids? Do you want to be intubated? Do you want feeding tubes? All kinds of stuff like that. You can say yes or no. A do not resuscitate. A lot of people think that a living will is a DNR. Those are completely different. A living will says if I'm already on a machine that's keeping me alive and there's no hope, I authorize removal of life support. A do not resuscitate is if my heart stops, don't start me back up. DNR, a do not resuscitate. So that's actually quite a bit different. Another thing that I sometimes recommend is I hate the name of this form, Declaration of Designee for Final Disposition. This is important for a lot of people, but it basically is designate who makes final arrangements. I often recommend this if we have second spouses and adult children. So we got a funeral home, you die, and then everybody comes to the funeral home. Who's in charge? Your new wife or your 3 kids? And the funeral home's in the middle and doesn't know what to do, and everybody has to agree, and they're all fighting, and it's terrible. So say, do you want your new spouse to be in charge, or would you rather your kids be in charge? And all of these things help you think about it and make a considered decision, and then communicate it to the people who matter. So I really think there's a benefit to going through the process of thinking about all this stuff. Let's see, I think that is basically it. Oh, the last thing is just what to bring to a meeting. If you are going to meet with an attorney to talk about estate planning, some of the things I often get people say, oh, what do you need? What should I bring? Important things that we need, obviously, is a list of your family members. Who are the likely beneficiaries, or who is going to serve as executors and trustees and all of that kind of thing. So we need name, address, sometimes phone numbers if it's putting it on medical power of attorney, because I want an emergency contact number on there. But mostly names and addresses of people that who are going to inherit or who are going to handle things for you. Also, if you want charities, we need actual legal names of charities, which sometimes are different than what people think. So I'm often Googling or calling, trying to figure out what the name is of the actual charity that people want to leave money to. Then when we talked about all that stuff about what is your estate, bring that list. All the stuff that you have, how title is held, who are the beneficiaries. That is really, really helpful information so that we can figure out. It also helps to know if you have debts, because we're trying to plan on, how do the bills get paid? Where does the money come from? So having at least a general idea of what mortgages or other debts we need to plan for. And then if you already have existing documents, that's often helpful. Bring those in. And sometimes I tell people you don't need to do anything. Those are good. Even though, the first person named is gone, you've got enough backups on here that, we don't need to redo them. You don't need to pay me to redo them because they're fine. So those are helpful too. So I often ask for those. Oh, we did it. Yay. Okay. So we can, how do I stop this? Okay. So that's it. I made it through the whole thing. And then if people have questions, you could put them in the chat. And I see there's something in the chat here. Okay, the chat question regarding retirement accounts, would those funds go to the beneficiaries right away or not until a future point in time? So any account that has a beneficiary designation is typically going to pass pretty quickly, because we don't need an executor. We don't have to have a judge appoint somebody and file the will and do all of that stuff. But So all they have to have is a death certificate, and then they call, whoever it is, TIA Craft or whatever, and get forms. They fill out the forms, and they can claim that money pretty quickly. Just like life insurance is pretty quick. So somebody says, how much does it usually cost to set up a will? Oh, wow. Well, I can give you the typical attorney answer. It depends. I will ballpark, if I have a couple and we are doing the basic set of wills, kind of the, I leave everything to my spouse, and if my spouse dies, then my kids, and kind of the basic thing. And we do a package like that with the power of attorney forms. So I do general power of attorney, medical power of attorney, living will, and wills for a couple. I normally say that is $600 to $800. I think most of the attorneys in Iowa City are somewhere in the $200 to $300 range per hour. So that's, roughly an hour of meeting with you, an hour of drafting stuff, and then an hour to get everything signed and all of that. So that's 3 hours. So $600 to $800 for kind of a very basic package. But if you get complicated, it's more than that, because I just base attorneys charged based on the amount of time they spend working for you. Okay, if children live out of state, is there a possibility of inheritance tax in their state, or does Iowa control? Iowa inheritance tax applies to the property of Iowa residents or the property of non-residents Iowa property. So like the guy who had I was talking about has 52 cousins. He actually lives in Florida. And so there's probate down there for a big chunk of his estate, but he also owned a piece of real estate here in Iowa. And so Iowa controls the Iowa property, even though he lives in Florida. And there is inheritance tax, but only on the Iowa farmland, which is still kind of a lot of inheritance tax. I think $50,000 or $60,000. So it's not controlled by their state. So all of the property of a resident of the state or the Iowa property if it's a non-resident. Okay. What is the name of the list of people you want to leave things to so that you can put it with your will? Oh, that's basically called a memorandum of personal property is what we call that. So it doesn't really, I don't think it has any official name, but do make sure that we can find that list. So I often have people give it to their lawyer and put it in the file with their will. Sometimes we don't look in the safe deposit box soon enough. I actually, had somebody who the will said, I want these rings to go to my cousins. And when the executors came in, I said, so where are those rings? They said, well, actually, she was buried with those. The rings are gone. So it does help if you tell people too, or give a list to, maybe give the list to, a copy of the list to the person who might be your executor. But that one, it can be very powerful, but we got to be able to find it. Wow, stuff is moving. So Bond got a question, what assets are taxable or potentially taxable at the time of death? A lot of people have this question about right away. How much tax am I going to owe from this inheritance? And that's a very complicated question, but I am a CPA and a lawyer, so I love that question because I'm really good with numbers and this is my thing. But the kind of short answer is most property passes free of income tax. Okay, so we're talking about a couple different things. There's death taxes, which is inheritance tax, and there's income tax, the normal income tax you pay. And most assets pass free of income tax. Okay. The couple of a big asset that passes that is taxable is retirement accounts. Retirement accounts, all that money went in pre-tax, came out of your paychecks, and you haven't paid income tax on any of that money. Normally it was in an IRA or 401k. When you pull it out, you would normally pay tax on that. Same thing applies to your beneficiaries. Whoever inherits that, they're going to pay tax on every dollar of that as it comes out, unless it's a Roth or there's some other exception. But typically your taxable retirement accounts are still taxable after death. And those have big tax implications. And they typically, unless it's going to a spouse, you only have 10 years to pull that money out. So it can really be a lot of tax owed on it. Let's see. If I have a will, but my wife doesn't, will my will be used in the event something happens to us? Well, your will only controls your stuff, and it only controls when you die. So it depends. If she dies first, there's no will, but she's intestate, so it might just go to you anyway. So I don't know. You better ask. Depends on your situation. Do I have any resources on how to talk about this with older family members that aren't prepared? Ooh, that's a good one. This is, one of the, I will say that the Honoring Your Wishes program really has, well, it's probably impaired some with COVID, but Honoring Your Wishes program actually is meant to help people talk about a lot of these issues. And they have trained facilitators who will sit down with someone who wants to do one of these forms and the person that they want to be their decision maker. So a person and their child or whatever. Normally, this is kind of an interesting question because oftentimes it's the opposite. It's the elders say, my kids don't want to talk about this. They don't want to hear about me dying. They won't even sit down and talk about it. So that goes both ways. And that's a really hard one. One suggestion I might have is that you do yours and then you share that. Oh, I've been working on my will. I went and talked to an attorney. She said, blah, blah, blah. That might be a good opener on how to do it. Or I learned this, or I learned that, or whatever. So that might be a way of opening a discussion. Also, I guess another way to do it is just say, it would really help me if I could be prepared when something happens to you. And one of the things I do tell people, I think, I suppose it's kind of corny when, you see these advertisements and they say, if you make your funeral plans, it's really helpful to your family. But it really is, because your family's grieving and you really want them going and having to figure out, guessing about what music you want at your services, or guessing about, a lot of this stuff. It's so, it really takes so much burden off of your family if you can give them this guidance and tell them what you want, because typically that is what they're trying to do, is they want to do what you want. Tell them what you want so that they can honor your legacy, honor your wishes, do what you want. I gotta scroll up here because like the questions there's so many of them, they're disappearing. Okay. Blah, blah, blah. Okay. How do I pick an attorney? How long does it take to get an appointment? That depends. How do you pick an attorney? A lot of times word of mouth is a great way of finding an attorney. I think you need to find somebody. It's kind of like, being comfortable with your doctor or being comfortable. I mean, you really do want to find somebody that you trust and respect and feel comfortable with. So call a few. I get cold calls all the time. People say, hey, I might want to do a will. What do you charge? Who are you? How long you been doing this? What area of law do you do? It's okay. Just call and ask. How long does it take to get an appointment with an attorney? That really depends on the attorney. Most of the time, I think it's relatively, within a week or two. It doesn't take that long to get in. Personally, I am just going into tax season, so would not be excited about making a whole bunch of estate planning appointments right this minute, but I still do have a legal practice while I'm doing tax returns. So it just depends on the attorney. And a lot of attorneys, I think most attorney offices are still open. A lot of them, people are working from home, but if they don't respond to you pretty quickly, then you probably don't want that attorney anyway. Is it preferable to name an individual to be an executor or a bank? Ooh, that's a good question. And I didn't cover that. I sort of run out of time. I can talk and talk and talk. I get paid to talk and I'm good at it. An individual versus a bank. Again, I'm going to say it depends. A lot of this depends on your family, your situation, your assets, your whatever, when I had my kids are pretty grown up now, certainly grown up enough that I'm not going to hold their money in trust. But when they were younger, or when I needed guardians, for me, I didn't really have good people in my family that could help me out. My sister's clear out in Utah, and my mom is older. And so I had a hard time. So, I mean, I was lucky that I did have a friend who was very capable and competent and willing to act as the executor or trustee for me. But not everybody has that. And you may not have good people in your family. Sometimes you might have somebody who's great, who might be a good guardian, so taking care of kids or helping out, but not necessarily good with managing money or, and these other issues, or being very organized. So, if you don't have all the right people, it may really be a good idea to have a bank helping. The drawback of a bank is that they cost money, and they would charge, fees. And so typically you can only, it only makes sense to have a bank if you have a relatively large amount of money. And by that, I mean 500,000 or more roughly, because fees start to go down, and they're a percentage. And otherwise you're using up too much of the money to pay the bank and not enough to go to your beneficiaries. But sometimes you can name a bank with a person, with somebody, a family member, and that kind of is a good matchup. So you could actually do a hybrid, a combo. So it just depends on the people you have available and how much you have in the assets and that kind of thing. And banks don't want, if one of your assets is a privately owned family business, a bank isn't going to be in charge of, doesn't want to be in charge of that. They want something that's relatively easy to manage, like, stocks and bonds, and sell your house, and that's enough. Okay, I think I might have hit all the questions. They're kind of flying by fast and furious, but I think I got most of them. Okay, this was awesome. And thank you very much for asking me to do it. I love doing this.
Well, thank you so much, Kandie. This was so educational. I have 7 pages of notes.
Oh, gracious.
So, well, I have a lot of talking to do with my parents, it turns out.
Oh, okay.
So thank you so much for this. Thank you all for coming.